either on the call or otherwise needs to hear it, they can do so. So now I'm going to go back and share it. And we'll probably post, we're going to try to post this on the website too. We should be able to do that. Okay, going back to what I was saying, 2020 has been a wild year in many regards, estate planning not being an exception to that. We've had a couple of major legislative changes this year. Some important case laws come out, and a number of things that affect our state plans, both from a Medicaid perspective and non-Medicaid, tax laws, retirement plans, all that. So we're going to cover all the major information today about what happened in 2020. We know that there's already some important developments coming up both in Medicaid and with powers of attorney that we'll be talking about in 2021. And hopefully by then we'll be able to have in-face meetings again on a regular basis, but we know the web concept works well. So without further ado, we'll start our program. Here we go. So just a couple of notes about what's happened in our practice in the firm. At the end of last year, I was fortunate enough to be invited to join the National Academy of Elder Law Attorneys Council of Advanced Practitioners. As it notes, this is a peer-nominated process, so current members had to nominate me and I had to be approved based on experience and all the stuff listed there. So it was a very nice honor, and hopefully it's a recognition of what we've all done here and to keep you folks on the cutting edge of where we are from the estate planning perspective. We've been joined in our practice by Linda Mitchell, who is a long-term prosecutor, as it says on the screen, with the DA's, Orange County District Attorney's Office. She's been in private practice for about 6 years, joined us earlier this year. And Linda's, among her tasks, are going to be assisting with the maintenance program as she gets fully acclimated and educated in our way of doing things. Our expectation is she will be doing most of the individual signing meetings and things that Megan's been doing for the last number of years. So that's a normal progression, and we are very confident you will find Linda as delightful as we do. She's a lovely person and really, salt of the earth kind of person. As far as some of the technology in the office, we're always looking to improve our technological base and tools that we use every day. So as we are seeing more and more estate administrations, people whose planning we've done have passed, and we've been inundated with them lately. We've recently subscribed to the Wealth Tracks Trust Administration System that is part of the Wealth Council system that we've been using. So all our documents are pretty much drafted in the Wealth Council system. And by having a all-in-one arrangement, this will make it easier to transition from the estate administration or into estate administration, since we'll already have all the client data entered in the system. So this will make us more efficient, more comprehensive, and make the administration process go more smoothly and quicker and less expensively at the end of the day. So we're very excited about that. We're just sort of learning that. It's a very detailed. There are like 126 steps you can take in various tasks that are included in the system. So we're figuring it out. So we're going to talk about some of the documents that some of the document updates we have. And there have been, in this current year, there have been a lot of big major document updates or some very significant law changes, but the document updates aren't too extensive. So Megan will take us into some of that.
Sure. And for those of you guys who have been with us for a while, you're pretty familiar with the process. So you're always given the opportunity, right, to make changes. but also the benefit of coming in year to year is because we're updating our language. And a lot of times those updates are just really building and bolstering the flexibility in your documents. We, none of us, as far as I know, if any of you can raise your hand, we can't predict the future. So we have to draft the documents to make sure that they include provisions that can address any number of situations that you or your family could be in the future. And so a lot of times when we're creating new language or implementing new language, it has to do with that. And so the first document update or language update that we started implementing this year, and will continue to be able to implement going forward, is going to be to the joint revocable trust. So for those of you who do have a joint revocable trust, you know, you and your spouse would be the trust makers. And here we're trying to build in some flexible options upon the death of the first spouse. So one of the provisions that we can use, take advantage of if it suits your situation at that time, we're using this language that adds a lifetime power of appointment, and we're going to talk a lot more about powers of appointment today, but it's like a power to amend the document. So again, flexibility. So we're adding a lifetime power of appointment that allows each trust maker to fund a family trust with the trust assets of both spouses. So this is not going to be the most appropriate option for many people, but we want to have it as an option for those people that it does make sense for. And essentially what it allows us to do, you'll probably recall looking through your documents that you do have a family trust there. And we probably have said maybe a few times in the past, whether you remember it or not, I don't know, but you know, less and less, fewer and fewer people are actually using that family trust upon the death of the first spouse. And sometimes it has to do with a tax conversation if it makes sense to utilize that family trust or your family situation. But this allows the trust maker upon the death of the first spouse to fund that family trust with more assets than they otherwise would have been able to do. So if that makes sense for you, we have the option, and it's not something that you need to know you need. It's when we get to that point and we're having that administration conversation, we know that this is a tool available to us and to you to really maximize the benefit of your estate plan. So the ability to push more assets into that family trust is there now because we've crafted some language to make that available to you. On the flip side, we also have some language that allows the trustee to add upon the death of the first spouse, right, to add the deceased spouse's share of assets in that joint revocable trust to the survivor's trust rather than putting them into a marital or family trust, as long as all of the beneficiaries consent and agree that this makes sense. And so that actually allows the surviving spouse to keep more or all of the assets in their survivor's trust share rather than pushing them over to the marital or family trust. Again, not appropriate in every situation, but we want to make sure that language is there so that you have the option if it does make sense for you. We never want to have our documents drafted in such a way where you're stuck in a bad situation. That's not how we plan.
Right, and the second point that is highlighted, really, that'd be most appropriate in a smaller estate where it just didn't make administrative sense to fund a family marital trust, which is really not a big deal to set up, but sometimes it just may not make sense. So if we have the flexibility to sit down with the family and say, you know, here's the different choices you have, and we're mostly talking to the surviving spouse in this conversation, you know, here's what can be done. Does this option make sense? And one of them is to say, okay, we'll move everything into the survivor's trust, which is a fully revocable trust. Now, there's some downsides on it too. The assets wouldn't be asset protected in that context. So every factor and every piece of information we have to deal with. So again, flexibility is the key, and this gives us more flexibility.
Another update is going to be to the retirement provisions, and you're going to find those both in your revocable trusts, whether they're individual or joint, and you'll also find them in the retirement trusts, clearly. And that's because there's been a major update to the retirement rules, and we're going to talk about that in depth in just a few moments. But generally, your documents as they stand today would have some conduit trust provisions, which is a special kind of trust to address retirement account needs. But before this year, before legislation has changed, they were really the go-to style trust for retirement accounts, retirement assets. So we're going to have some of that conduit language in your older trusts, but now in the updated trusts, we may still have some conduit language, but we are adding additional language that doesn't leave the conduit trust as the only option anymore. And again, we're going to talk about this more in depth, but I want you to be a little bit familiar with the conduit trust and also accumulation trust. So those are really the two kinds that we're talking about. So previously you would have only had some conduit language in there, but now you're also going to have accumulation trust language in your documents. So even if you have no changes that you desire to make yourself, this year is a really important year that you come in and update your documents, because we are going to be altering some of this language in the retirement provisions of your trusts. And then to the ancillary documents, we just have a few little minor things. One really nice thing is that, as Rich explained, we do use some drafting software, and that software now gives us the option to include a sort of gray box around the signature line or over the signature lines, which hopefully makes it a little bit easier for clients who have any kind of vision impairment to be able to see the line where to sign. We are also utilizing a lot more sign here stickers than we had been previously, and that's mostly due to COVID, but anything that we can implement to make it easier for our clients, and also to make sure that we are staying socially distant and I'm not hovering over you pointing at where to sign, right? So we have that available to us if it is needed. We'll probably only be including those gray boxes where it makes sense. So if you are having any kind of difficulty, do let me know, because I can include that in addition to those sign here stickers for you. In the wills, we just added a definition that really makes the terms shall, must, and may a bit more consistent. So we wanted to clean that up a little bit. I think we were using those a little too loosely or interchangeably previously without really something solid, a provision in the document itself to clarify and make all of those things nice and consistent. So we've added that to our wills as well.
Okay. So now we're going to talk about some of the key legislative changes for the year. So first we'll start with our annual conversation of the estate and gift tax exemption amounts. This year, 2020, if a person passes away, their federal estate tax exemption amount is $11,580,000, which is also the total amount of lifetime gifts a person can make before their tax. So that's a big number. Obviously, very few estates should be paying any estate or gift tax in this world on a federal basis. The New York State estate tax number in 2020 is $5,850,000. So it looks a lot like this, just coincidental that they're sort of a transposed number. So just short of $6 million per individual in New York. So I'm administering an estate right now where there's about a $6.5 million estate. So there is some New York State estate tax being owed, no federal estate tax being owed. As I note here, while New York State doesn't have its own gift tax, if you do make gifts in excess of the $15,000 per annum gift exemption amount, and you die within 3 years, those amounts will come back into your estate. So one exception to the no gift tax rule in New York. Our gift tax exemption for the annual amount that you can make a gift to someone without having to worry about filing a gift tax return is $15,000, as it's been for at least, I think this is the third year or so that we've had $15,000. We'll see in 2021 if it goes up. It goes up in $1,000 increments as inflation increases, but because inflation has been so low, the gift tax exemption increase is slowed down as well. Community Medicaid rules, we have a few changes, and I see there might be a comment here. Oh, any changes to exemptions for Pennsylvania have been asked? Not that I'm aware of. In fact, I'm quite sure there have not been any Pennsylvania changes in the inheritance or estate tax there. Community Medicaid rules have changed. And again, this is a New York specific case. I can't speak to Pennsylvania. We don't do Medicaid really in Pennsylvania. I do have a colleague there who we can call upon if someone has a Pennsylvania Medicaid case. This is new, as it says, until October of this year, and it's probably being pushed off until January of 2021. But regardless, for the first time in New York State, there will be penalties imposed for certain transfers of assets for Medicaid eligibility purposes for someone receiving community-based Medicaid services. That's care in your home with a home aide or assisted living facility. Until now and through now, you can go into a nursing home, have $1 million, not a nursing home, assisted living facility, or get care in your home, transfer $1 million to your kids, and get Medicaid the next month, which has not been the case in most states. New York's been an outlier. So with the large budget deficit we had, and this is pre-COVID, so going back to February, the governor appointed a Medicaid redesign team to come up with ways to shore up our Medicaid deficit. We had a $6 billion state budget deficit, and unlike the federal government, the state can't just print money, so they have to balance the budget. So one of the recommendations of the Medicaid redesign team was to impose a community penalty Medicaid penalty, a community Medicaid penalty for asset transfers. Now, the exemptions that apply for nursing home Medicaid apply to community Medicaid, which the most important one is a transfer to a spouse. So if we have a married couple, the community Medicaid planning will not change in any significant way. Where it will apply will be when we're dealing with a single person who needs to get services in the home. We're going to have to implement most of the same techniques that we use for nursing home Medicaid strategies that we do. We'll have to implement those for community Medicaid, the most common of which is what's called the half a loaf strategy, a gift of half of the assets approximately and a loan of half of the other assets. The one piece of good news in this whole area is that the Medicaid redesign team had recommended repealing the spousal refusal rule, but that was not put into the final budget that was passed. So spousal refusal, which is a very important planning tool, remains in effect for both community and nursing home Medicaid cases, which again allows us to transfer any amount of assets between spouses and have the spouse needing care almost immediately eligible for nursing home or community Medicaid services. Megan, anything to add that I didn't cover on that?
I don't think so, but I do want to just make it clear for those of you guys who did some proactive planning with us already, so maybe that includes a Medicaid Asset Protection Trust, that is going to be an effective planning tool to address this look back period as well. So when we're talking about the 5-year look back, we're also considering now this 30-month look back period, but the planning is going to be about the same. We're just talking about 2 different look back periods, right? 2 different clocks ticking for purposes of community Medicaid versus nursing home.
We have a question reverting back to the gift tax conversation. If we provide a lump sum to a child to assist them in a real estate purchase, does this fall outside of the annual gift tax? Well, assuming you're giving more than the $15,000, what that means is you will be utilizing a portion of your lifetime gift tax exemption. So to make it simple, you make a gift of $115,000. $15,000 of that is exempt. $100,000 will come off of your $11,580,000 exemption, leaving you with a mere $11,480,000 of gift tax exemption remaining. Now, the only major issue with it is not that you'll pay gift tax, but you are obligated to file a federal gift tax return, which is not a big deal, but is one extra thing you'll have to do to memorialize that gift. So hopefully that answers your question. Moving ahead. So we're going to talk.
I'm sorry, I was just going to say, if you guys are thinking of doing any gifting, major gifting, do feel free to run that past us. You're in the maintenance program, so give us a shout or send us an email so we can make sure that it's not going to interfere with the plan or there's not a better way to do it. So
yeah,
just
and
let us know.
I believe the person who posted that had spoken to me about the gifting too.
Yeah.
One thing that should be said is that the question before was about the gift tax, how does it affect your gift tax? It won't, except to the extent we mentioned. However, keep in mind, if you do give that $115,000 gift, that will be a Medicaid gift or count as a gift for Medicaid purposes, almost certainly, if you apply for Medicaid within 5 years. There are exceptions to it, and it may fall outside, with one of the exceptions, but it's really beyond what we can talk about today for that. But as Megan said, run it by us so we can clear it with you and make sure everything is good. So we're going to spend a next few minutes talking about the Secure Act, which is a very significant piece of legislation that changes a lot of the rules pertaining to IRAs and other retirement accounts.
So the Secure Act is actually the Setting Every Community Up for Retirement Enhancement Act, but secure is much nicer to say, right? And the Secure Act initially passed the House of Representatives back in May of 2019 by a vote of 417 to 3. So we could see this coming down the pike, and we may have even mentioned it to a few of you towards the end of last year. Then the Senate passed the act in December of 2019, and the next day President Trump signed it into law, and it went into effect as of January 1st of this year. So here we are mid-September, and this act has been in effect all year long so far. So for those of you who, you all should have received some papers we sent on it, but we can talk about this further, certainly how it applies to your specific circumstances when we sit down too. And we're going to go over it in broad strokes here.
I just want to say, and I haven't mentioned this in the past, but realistically, from a proper English standpoint, this should be the Setting Up Every Community for Retirement Enhancement, but then they couldn't spell out secure. So they had to bastardize the phrase to make it have the acronym that they wanted. Just an observation that means absolutely nothing.
So we're going to run through some of the provisions. This is not all encompassing, but these are going to be the major things that we think will affect you guys. You're going to want to know about. So first, the Secure Act actually increased the required beginning date for required minimum distributions. So you probably all have it ingrained in your head, right? At 70 and a half or shortly thereafter, you'll have to start taking your required minimum distributions from your retirement accounts. So now you have a different number to age to memorize. It's actually now 72. You don't have to start taking them until you are 72 years of age, at which point you'll take your required minimum distributions, and it'll be based on your life expectancy. The Secure Act also repealed the maximum age for contributions to traditional IRAs. So you can continue to contribute to your traditional IRAs as long as you are still working. And it also allows for some penalty-free withdrawals of $5,000 by each parent in the year of birth or adoption of a child. So trying to help out the younger folks, the younger generation, with starting up their family and things of that nature. I know we're far along into the year here, but for those of you who didn't take your RMDs yet this year, due to COVID, not actually having to do with the Secure Act, but due to COVID, you don't have to take your required minimum distribution this year. So if you didn't take it yet and you don't need to take it, that's something that you might want to think about, maybe passing on it for this year in particular.
Right, and that'll save you some taxable income, which can always be a welcome relief.
Right. So now here's sort of the sticky part of the act, the part that we are not all that excited about, frankly. The new Secure Act requires most, and we're going to talk about a few exceptions, but most non-spouse beneficiaries to withdraw inherited account balances within 10 years of the account owner's death. So this is a major change to how these assets were treated in years prior to this year. So we're talking about non-spouse beneficiaries. So this would apply to those of you who have someone other than a spouse listed as your primary, or upon the second spouse's death, to those individuals listed as your contingent beneficiaries, which may be kids in many cases, so adult children and so on. There are a few exceptions to this rule, right? So the rule now, the hard and fast rule, is that your beneficiaries would have to withdraw the entire account balance within 10 years of the date of your passing. So that's the rule unless the person fits into the exception. Now, a spouse is an exception, and then you have some other beneficiary exceptions here. One includes minor children of the account owner. They can actually take the distributions based on their life expectancy, so it'll be smaller amounts annually until that child reaches the age of majority, at which point then they need to deplete the account within a 10-year period after they reach age of majority. So they don't want to force the funds out to a minor child, right, I guess is the idea. So they're going to take much smaller amounts until they are age of majority there.
Right. So if an 8-year-old happens to inherit a parent's IRA, they can then use conduit or life expectancy distributions for the first 8 years. Then when they turn 18, then they have to withdraw the balance over the next 10 years. So effectively, they get a 20-year period in which they have to withdraw it all.
Right. And I'll just, I mean, I know it's probably obvious to you guys on the call here, but the idea is that when these funds are coming out, right, they're taxable. So it's nice if we can stretch that out a little bit over a course of many years instead of having to take it out in a 10-year period, because as the funds come out, they're going to be taxable as income.
Now, Megan, we have a question. Does this also apply to Roth IRAs?
Where's the question? Well,
and the question
the answer is no, right?
Well, no, the in terms of withdrawal requirements. The answer, yes. So a Roth has to be withdrawn in the same time period. It's just not taxable income at that point.
Right.
So if you have if your 50-year-old child is your beneficiary of your Roth IRA, they will have to withdraw that over a 10-year period. Just they won't pay tax on it, but it will not receive that tax deferral beyond that time.
Right. So it's still a concern, but it's not as much of a concern with regard to the tax implications, as Rich is saying, right?
Right.
A few other exceptions to the 10-year rule are for those disabled individuals or chronically ill individuals. They are permitted to take the distributions over their life expectancy instead of forcing the funds out in the 10-year period. And then the last one is an individual who is not more than 10 years younger than an account owner. So this could be if a person has a sibling listed as a beneficiary, or maybe in a situation where a couple is not actually married and they have each other designated as their beneficiaries. So they wouldn't qualify for the spousal exception, but they would get the stretch out if they are within 10 years of age of the account owner. So now we're kind of faced with this when we're drafting this conduit conundrum. So based on what the rules were previously, beneficiaries had the option or had the ability, I should say, to make withdrawals based on their life expectancy. And so to address that benefit and sort of preserve that benefit when we're doing the planning, we would draft trusts with these certain conduit provisions in them that would allow that beneficiary to still keep that stretch out that's created when they take the required minimum distributions based on their own life expectancy. So starting out with smaller amounts and gradually getting larger as they get a bit older. And so the provisions were carefully constructed to make sure that they don't lose that ability, because it's nice to not have to take out as much funds getting hit with the income tax consequences, and to be able to leave a bit more in the retirement account to get the tax deferred growth. So what the conduit provisions basically did was included some language that said those required minimum distributions would pass through the subtrust that we've created for the beneficiary, like a conduit, right? The trust is acting as a conduit. And by allowing or by mandating those required minimum distributions to go through the trust direct to the beneficiary, that allowed any other excess amounts to be held in the trust. And there was also language that if something happened to that beneficiary and there was some kind of concern about the protection for the assets, we had a mechanism where we can turn off the conduit language, the conduit force of the assets, right? So we had this constructed this way to preserve the stretch out But essentially now with the new legislation, most of the beneficiaries are not actually able to have that stretch out ability, the stretchability, I guess it would be, for those retirement accounts. So why are we talking about forcing funds out of the trust where they become exposed, right? Instead, it seems like it's probably a better option rather than force the funds out to allow them to accumulate within the trusts that we're creating so that they are creditor protected and protected from divorce and illness and all of these things. So as the legislation changes, we're really finding out that maybe the conduit language isn't as favorable anymore because we're trying to preserve a benefit that's not available.
Right. So this slide just sort of shows an example of why the conduit, which was a great thing in the past, is no longer really a viable option in most cases. So under the old law, if you had a 25-year-old beneficiary, their life expectancy factor was 58.2 years. Basically, you would divide the total amount of the IRA they're inheriting, I use that term IRA for all retirement accounts, over the divided by the 58.2 years, making the distribution very small. So the conduit payment would be very small, especially in the early years, resulting in a very low amount of income tax. But under the new law, if we had a conduit, then the RMDs that they would be taking out under the conduit would be much larger, and all the assets would have to come out of the trust over 10 years. Now, regardless of what kind of trust structure we use, the withdrawal has to be made from the IRA over a 10-year period. But in a conduit, none of it's going to be trapped in the trust with all the trust protections. It's all going to be out within 10 years. With the accumulation trust that we'll show you in a moment, we can keep more of that in the trust protected against creditors and divorcing spouses and creditors that we are worried about for our beneficiaries. Right. So again, we talked about it having to be distributed, so it would not be protected. So I've really sort of mentioned this slide material here. So conduit trusts only really work for younger beneficiaries until age of majority.
So now we're trying to figure out what the conduit solution is, right? What's the solution to that problem that we might be facing? So I guess it puts us in a position, the new legislation and the old style drafting that we had available to us, right? Because most non-spouse beneficiaries are withdrawing the entire balance of their retirement account within the 10 years, unless they fall into that, except those few exceptions that we described. And so we don't love the conduit language because, as Rich just described, that means a lot more of those assets, the full retirement account, which can be hefty, right, is coming out of the retirement account through the trust under the old language and out to the beneficiary. So then we are now considering using some accumulation trust language instead, which would allow those funds to accumulate within the subtrust for the beneficiary, giving them the maximum amount of protections, the creditor protection, divorce, illness, all of that great stuff that we are trying to incorporate in your estate plan for your beneficiaries. The tricky part becomes whether or not your beneficiary should elect to leave those assets in the trust or to withdraw some or all of them on a given year, because the trust is taxed at a different rate, a more compressed rate than your individual beneficiary would be. So if they are, and as you know, the assets coming from most of your retirement accounts are going to be taxed as regular income, right? So if they are allowing those funds to accumulate in the trust, that trust may incur higher tax liability if the beneficiary leaves those funds there. The nice thing about the accumulation trust is it actually gives the trustee the ability to make that assessment, hopefully with other professionals, right, accountants and such, to determine what the best method would be. It gives them that sort of discretion to let the funds accumulate in the trust if it makes sense for the beneficiary, and oftentimes the beneficiary is their own trustee. So they can leave the trust, the funds in the trust and allow them to receive that creditor protection and all those things, which is especially appropriate if the beneficiary is in a situation where they need it. or they can decide to withdraw some or all of those funds and put them in the beneficiary's name to sort of reduce that tax liability that the beneficiary would incur. So the nice part about the language is it gives them the option to determine which one is going to be better for their situation in any given year or any given time. And that's sort of the thing that they will have to balance. I mean, I think it's apparent to us that the accumulation trust is the most appropriate language for most of your beneficiaries, unless they fall within the exception. And then down the road, when they do inherit the assets, it'll be up to them to make the determination to leave it in trust or withdraw it to mitigate some taxes.
So we did have a question, a good question about what about people who have previously started to take their RMD prior to 2020? Well, if it is your own retirement account, nothing really will change. If it's your own IRA, for example, you'll be taking it over your life expectancy using what's called the Uniform Lifetime Table. That was not really affected by the new law other than deferring your RMD date from 70.5 to 72. If you're talking about an inherited IRA, you're governed by the old rules. If you were taking distributions, if you inherited your parents' IRA in 2019, you're still able to use the life expectancy table. The new rules only apply to someone who inherits an IRA from January 1st, 2020 and beyond. So hopefully we answered the question. If not, you can clarify it in the chat box.
So what we are encouraging each of you to do, and I mentioned this earlier, if there was ever a year to come in and update your documents, right, it would be this year. Even if you have no changes that you want to make, we are updating our language in each of the trusts. The revocable living trusts do have some retirement language in it, and also certainly your retirement plan trusts for those of you who do have them. We're going to want you to come in and make sure that those get restated or are restated because we're going to update some of that language. Now, we're going to take a look at what your particular situation is. If the conduit language still makes sense, of course, we're going to keep that in the documents for you. But if it doesn't make sense anymore for your situation, for whoever your named beneficiaries are, then we're going to update your trust to include that accumulation trust language. And if you have beneficiaries that fit each category, maybe one falls in exception, one doesn't, then of course we're going to customize the document to fit your particular needs. But we do need to update your documents this year. It will also be important for us to review your beneficiary designations, because when subtrusts are named as beneficiaries, it's very specific language that needs to be used. So we're gonna, if you guys want to do any homework before you come visit me this year, or if you end up sitting with Linda, please maybe do a printout of what your beneficiaries are on your different retirement assets, so we can just verify that they are named correctly. And if it should be your subtrust, we want to make sure that language is accurate. So now we have some additional planning options, trust options that you can utilize based on the changes in legislation this year. So the first one we sort of highlight, and some of you may already have this particular kind of tool. This is the standalone retirement trust, and now they are being drafted with the accumulation provisions. And if you have one already, like I said, we'll restate yours to include this language. But these trusts are used specifically for retirement accounts. And as you know, we don't change the ownership of your retirement accounts, but these trusts in some form with very careful language would be designated as the beneficiaries of your retirement assets. And these trusts have very carefully drafted language to address all of the nuances associated with retirement accounts. As you know, there are different kinds, and there's tax deferred benefits and so on and so forth. So we don't want to mess that up at all by using the wrong language. So these are carefully drafted trusts to address the nuances of retirement plans. And we would recommend these usually for people who are in the 200 to 250,000 or more range for their retirement assets. So if that's you and we have not discussed this yet, please make sure to wave the little flag and let me know, because we probably should talk about it. But yeah, so we're going to have that accumulation language in the documents, and I think I've already described to you those accumulation trust provisions.
So because the acceleration of withdrawals from an IRA will result in almost every case in more income tax being paid out by the beneficiary, and perhaps it result in less money going into their pocket. There are some options to sort of help balance or make up the difference in those cases. And one of them is our old standby, the Irrevocable Life Insurance Trust, or ILIT as it's referred to. So essentially, this is a mechanism to purchase life insurance that will provide some additional cash to your estate, so to offset the accelerated income tax liability. By having the life insurance owned by and the beneficiary of, having a trust, the beneficiary of the life insurance, the proceeds can go into a protective trust, fully exempt from the creditors of the beneficiaries, divorcing spouses and the like. And in most times, if it is an irrevocable trust, the assets, the death benefit will be outside of the taxable estate if you have a large enough estate where estate tax is a concern. So we've used a life insurance trust for years for estate tax liability protection, but now it's also being looked at as a way, as a replacement for lost retirement benefits. Another idea is the charitable remainder trust. And I just actually illustrated this for somebody. Really a good option to consider for those who are already charitably inclined, even though the beneficiaries may not get as much as under the standard 10-year payout rule. So essentially what would happen is, let's say you have $1 million IRA. If you gave it, named your child as the beneficiary, they would have to withdraw it out over 10 years. So if they took $100,000 a year, they'd have $100,000 of taxable income for 10 years. What if you instead have it left it to the Richard Shapiro Irrevocable or Charitable Remainder Trust? Now, I'm not asking you to leave yours to my trust. I'm using myself as the example. So if I left $1 million to the Richard Shapiro Charitable Remainder Trust, and I named my children, Emily and Aaron, as the life beneficiaries of that, they could each get 50% of income. And let's say I said a 6% payout a year. So in year one of $1 million, $60,000 would be paid out, $30,000 to each of my kids. They would pay income tax on that, but that could allow it to be paid out over their remaining life expectancy. So they'll get payments for the rest of their lives. Then when they pass away, whatever's left in that trust will go to one or more designated charities, tax-free. And if I'm concerned that my kids might get less in that way, again, I can then use ILIT, the life insurance that is 100 cents on the dollar will pass to my kids. So, between the ILIT and the CRT options, there are some pretty interesting ways. Another one we don't have a slide for, but that is also a consideration, is doing more Roth conversions, converting your traditional IRAs to a Roth. You'll pay, of course, more tax now, but because it's a Roth, even if it has to be paid out over 10 years, it's not going to be taxable to your beneficiaries. So if you're willing to bite the tax bullet today, and especially given the likelihood that income tax rates are going to increase over the next decade or two, which it's hard to imagine they will not, given all the deficits we have and so on, a Roth conversion might be a viable way to go. Bottom line is, very important to make sure your beneficiary designations are correct and that they're kept up to date. And certainly Megan and Linda and the rest of our team will work with you to make sure that your beneficiary designations are and will remain correct based on your needs and goals and your planning structure. So now we're going to shift to a couple of very interesting cases. I asked Megan last year to do some research on some of the case law in our in estate planning and elder law, and she came up with some fantastic cases, and we just had to whittle them down to two just for interest of time. So here are two really useful cases that we always like to say help demonstrate the planning you've done with us You will not be the victims in one of these cases, but they're a very interesting reading from our perspective. So why don't we talk about a couple of these cases?
Sure. So the first one is In re Mandel, and this is a case about a widow, Mrs. Mandel, who died with a $5 million estate. So not really chump change here, right? And she had no children, and she was survived by two sisters. Her stepson, so she did have a stepson apparently, and her brother-in-law submitted the will for probate, and her sisters, who were not included in the will, so they weren't named as beneficiaries, filed objections. So they probably didn't like that they weren't named as beneficiaries, right?
Right. And keep in mind, and their motivation here is this. If they were successful in getting the will thrown out, and let's assume Mrs. Mandel did not have another will, the two sisters would get everything under the laws of intestacy. So they had a significant incentive, or $2.5 million worth of incentive apiece, to get this will tossed.
Right. So the stepson, or if he was deceased, his issue were the primary beneficiaries of the will. The will also included a pet trust for the decedent's many pet birds. At the time the will was executed, there were no markings. So you guys probably recall whenever we do a will, maybe we've updated your will, we're very particular about the signing of the will, right? You only execute the one original, and then I take it back from you, and we keep it someplace safe to make sure that there are no additional markings. So when she signed the will, there were no markings, but by the time it was admitted for probate, a number of sections had been crossed out and handwritten additions were made. The decedent's initials also appeared on the document. So apparently in her situation, she executed the will, but maybe she was able to take home the original, which is a deviation from what we typically do, and for good reason, you're going to find out. So hers had markings on it. So among the sections that were crossed out was the disposition for the stepson, and the court noted that under New York law, revocation of a will requires both intent and specific physical acts of obliteration or cancellation in order for the will to effectively be revoked. And that's what the sisters, as Rich explained, are aiming for, revocation of the will. The court noted that to constitute a sufficient physical act, the entire will or a vital part thereof must be obliterated. So here, the court held that because significant parts of the will remained intact, which ended up being about half of the provisions, and because the signature and witness sections were undisturbed, the statutory requirement for revocation had not been met. As a result, the court dismissed the sisters' objections, and the will in its entirety, even including the provisions that had markings through it, was admitted to probate. So this is exactly what the sisters didn't want to happen, and now we can look at this sort of two ways. Here, Mrs. Mandel took her original will home, and someone got a hold of it, maybe one of her sisters, maybe someone else, and drew on it, crossed out some provisions because they didn't like it, and the court ruled correctly in that that wasn't Mrs. Mandel's intent, and so they're going to keep the will in its entirety intact, and they'll be probated accordingly. Or maybe Mrs. Mandel did want to cross out those provisions and did want to change her will, but she didn't go about it the legal way. So now the court said that the will is not revoked, right? And those changes to the will that she tried to effectuate in that example are not going to be upheld, which is in contrast to what her wishes would have been if she was the one who truly made those markings on the will. So this is very tricky, and I think that the lesson to be learned is that it's important to keep your wills in a safe place where they can remain pristine. And if you want to make updates to your documents, you should do it in the legally mandated way, which is really to just execute a new will. Don't make markings on it. Just come in and do a brand new one that accurately reflects what your wishes are. Because either way, this can't have been a good situation. It probably costs a lot of money. And in either way, if Mrs. Mandel was looking down from her cloud, right, she wouldn't be happy.
Yeah, I mean, I think it's much more likely the second scenario played out, because if the sister took the will, they would have destroyed the whole thing, is my guess.
Yeah.
So I do think Mrs. Mandel probably did make those markings and did think she was doing what she wanted. But, for a woman worth $5 million wouldn't spend the money to be a lawyer. She got what she deserved, in my humble opinion.
Right. So the next one here is matter of Durcan. In this case, the decedent transferred various investment accounts while they were alive from one brokerage firm to another, including 4 IRAs. And this happens lots of times. Maybe some of you have done it. At some point, you decide you're no longer happy with the institution you're working with, or your financial advisor, your trusted person, moves to a different institution. And so you move over to them, right? And you're going to bring your accounts with you. And that's what this individual did here. At the prior brokerage, her sister was designated as the beneficiaries of all of the IRAs. So she filled out the appropriate beneficiary designation forms that named her sister on all of those. At the new brokerage, a client data form, probably a lot like what we've had you fill out in the past, a client intake worksheet, specified that the sister was to be the beneficiary of the IRAs, but no beneficiary designation form was found on file. So maybe she filled one out and it got lost, or maybe she never got around to filling out a beneficiary designation form, but her client data sheet did indicate that she wanted to keep her sister as the beneficiary of those retirement accounts, just like she had at the old brokerage firm. Nonetheless, the investment firm established inherited IRAs for the sister based on the client data form and personal knowledge of the employees of the decedent's intent. So after she passed away, the brokerage firm operated as though she had appropriately or properly filled out those beneficiary designation forms naming her sister, and they set up that inherited IRA for the sister. And it seems like she probably worked pretty closely with the employees at that brokerage firm because they seemed to know that that was still her intent at the time she moved over and she passed away. Then the decedent's brother got himself appointed as the administrator of the estate of the decedent. So now here we are faced with a unique situation, or maybe not that unique. In this case, the decedent designates, or would have liked to have designated, her sister as the beneficiary of those accounts. But she also had a brother, and he was not named as a beneficiary on the accounts. So apparently she also didn't have a will, and the brother got himself appointed as administrator of the estate, which happens when there's no will. And he filed a petition for a turnover proceeding to have the IRAs ordered to be paid to the estate. So if you don't have a beneficiary designated on your accounts, such as your retirement accounts, then your estate is going to be the beneficiary. And this works in the brother's favor because the decedent having no will, that would mean that her assets, her estate assets, would pass under the laws of intestacy, which, presuming she had no spouse, no children, and no surviving parents, that would mean her brother would end up with a portion of her estate. And if he was left out initially, he certainly is going to want to go after those funds, right?
Right. So let's see what the result is.
The court held that the client data sheet did not satisfy the requirements of New York law, which requires that a beneficiary designation form must be in writing and signed by the person purporting to make the designation in order for it to be effective. Therefore, the decedent's sister was ordered to transfer the IRA proceeds to the estate, where, like I said, they'll pass under the laws of intestacy and the brother would receive a portion. So if it's just brother-sister, they would split it 50-50. If there are some more family members involved, it would be even a smaller share for the sister. And because we're talking about retirement assets, there's actually a huge negative implication. There's an accelerated sort of payout when the retirement accounts are payable to an estate instead of a designated individual. So that's even doubly negative for that sister. And you can imagine the decedent was probably rolling over in her grave saying, why didn't we just do that beneficiary designation form? We could have avoided all of this, right?
Yeah, and because this was pre-Secure Act, the sister, had she been the properly designated beneficiary, could have used her own life expectancy for taking the withdrawals. Once it went to the estate, if the deceased sister had not already been taking her required distributions, then the estate would have to withdraw the entire IRA over a 5-year period, which would be a greatly accelerated income tax issue. So yeah, the only one who benefited here is the brother, and more power to him for getting to the right lawyer to file the proper claim, but certainly not the result that the deceased sister certainly was looking to accomplish.
Right.
So now we're going to move ahead to our planning spotlight, which will cover the rest of the discussion today. And the power of appointment is something we've been using for 20, since I've been doing estate planning of this nature for 21 years now, and we deal with it every day. But many clients are pretty unfamiliar with the concept, even though in our planning meetings we've talked about powers of appointment. But we understand so much is going through your head, and you're focused on so many things. You probably aren't giving full attention to what the power of appointment is. So we thought this was a good opportunity to revisit this issue and really explain what it is, so you can consider if your existing powers of appointment that you have in your documents, and I would submit that pretty much everyone on this call has powers of appointments in one way or another, whether you need to revisit them and adjust them. So we'll start off this with a very powerful statement, as it were. It has been stated that the power of appointment is the most efficient dispositive device that the ingenuity of Anglo-American lawyers has ever worked out. And this was by a famous attorney, W. Barton Leach, who wrote this in the American Bar Association Journal all the way back in 1938. So powers of appointment are nothing new or exotic. They've been around for hundreds of years. So what is a power of appointment? Quite simply, powers of appointment are provisions in a will, a trust, or even it could be in a deed or other dispositive instrument that provides someone, some other person, or even the person who's granting the power can retain the power. It gives someone the power to direct the ultimate disposition of assets contained within a trust. So New York has a specific statutory section in the Estate Powers and Trusts Law listed there that governs powers of appointment. And powers of appointment can be held during lifetime or exercised during lifetime, hence called a lifetime power of appointment, or reserved for testamentary dispositions, meaning dispositions that are directed through a testamentary instrument like a will or a trust, known as a testamentary power of appointment. And powers of appointment can be either general or limited. A general power of appointment, as the name implies, allows the power holder to appoint the property subject to the power to any person or entity, including the power holder's estate or creditors of their estate. Now, no one in a logical world would ever appoint their property to their creditors or the creditors of their estate, so that's not really what it's all about. By having the power to do that, however, it causes the trust assets to be included in the power holder's taxable estate upon their death. Now you would say, why would that be a good thing? Well, in the old days with the low estate tax limits, it probably wouldn't have been a good thing. But now, with the very large estate tax exemptions that we discussed earlier today, having property included in a person's estate is usually a good result, because what it does, it ensures that there's a step up in cost basis for the trust assets upon the beneficiary's death. So if I have a power of appointment over $1 million in a trust that's been left to me by my father, and if I have a general power of appointment and I pass away, that $1 million in that trust will be included in my estate. But if my estate is worth less than $5,850,000 as a New York resident, I won't be subject to New York estate tax or federal estate tax. However, the full $1 million in that trust that I have the power of appointment, even if I never exercise it, will receive a full step up in basis. So if I inherited that from my father when he passed, he's still living, thankfully, and he had the assets in that trust that are worth $1 million at the date of his death, but he had paid $300,000 for those assets, there's a $700,000 gain. That gain is wiped out when it passes to me and I have the $1 million and then I die. it'll get a full step up in basis to the $1 million fair market value, and then my kids, presumably, or whoever else inherits, will pay no capital gains if they liquidate those assets. So general powers of appointment have very strategic tax planning benefits. We also have the limited power of appointment. And as the name implies, that restricts who the power holder can leave the property to. Typically, a limited power appointment will restrict dispositions to the power holder's descendants, or sometimes descendants and charities. So in cases where a parent doesn't want their children to leave it to a spouse or someone outside of the bloodline, they can provide them with a limited power of appointment. By having a limited power of appointment, oops, I hit the button by accident. By having a limited power of appointment, the assets will not be included in the taxable estate of the beneficiary, and there will be no step up in cost basis of those assets at the time of the beneficiary's death. So if I inherit property that when I inherited it was worth $500,000, and over the course of my lifetime has grown to $1 million, there's a $500,000 gain. If it's a limited power of appointment and my kids inherited it, they will take my $500,000 cost basis. If they sell the property, there'll be a capital gain of $500,000 and a fair amount of tax owed. But by having limited power of appointment, I can't leave it to someone who the person who granted the power to me would not want me to leave it to. So those are the big broad brush categories.
So we have a few common uses for these different kinds of powers of appointment. Sometimes you will see a power of appointment provided to a surviving spouse, and this gives that surviving spouse the authority to appoint assets in a marital and or family trust, if we're in a situation where family trust is created, at death to the couple's descendants. Doesn't necessarily have to be limited to descendants, right? But by limiting it to descendants, we're creating that sort of bloodline protection that many of our clients are interested in. So it really restricts who the surviving spouse can reallocate those assets to that are passing through that marital or family trust. And then oftentimes, and again, this is a result of the counseling conversations that we're doing with you guys, but oftentimes there would be no power of appointment granted to a surviving spouse in a second marriage situation if we have some kind of concern about maybe that surviving spouse appointing to children from their prior marriage, or it's somehow allowing that surviving spouse to designate or allocate those assets to someone that wasn't the intention when you did your planning originally. So we may together decide that no power of appointment is appropriate based on your situation, or together we might say maybe just restrict it to descendants or something else.
Right. And with this top portion, the most common use can be very powerful in, let's say couples married, 50 years, husband dies, wife lives another 15 years. And between the date of the husband's death and her death, she has an estrangement from one of the children that, they have 3 kids and everything in their plans that it leaves equally to, Tom, Dick, and Harry. And wife has an estrangement from Harry. By having a limited power appointment among descendants, she could then modify the disposition of those trust assets to exclude Harry and leave everything to Tom and Dick. Not to her new boyfriend, but to among Tom and Dick or the grandchildren. So it does, as I like to say, and I've said this in client conversations, if you want to make sure that the kids still send mom the Mother's Day card every year, include a limited power of appointment, make sure the kids know that mom has the right to cut them out regardless.
You'll also see the power of appointment used, and it's granted to children, and you can either do a general power of appointment or a limited power of appointment, and then restrict who your children can allocate or distribute those assets to after they pass away. So you will see this in sub-trusts created for your after-death beneficiaries, whether it's children or maybe it's other people that you've created a sub-trust for. But you can, in their trust, give them a power of appointment, and which one you choose will again be based on what your goals are and your wishes are. for those assets and where they go once the child or other beneficiary passes away. And you'll see that in their subtrust, and they would exercise it by doing their own estate plan and say, I've been given this power of appointment, right? And they're going to exercise it to direct those assets in some other fashion, either among any person or entity. So maybe they're charitably inclined, so they leave some to a charity, or if you restrict it, only among those people or in charities that you've restricted it to.
Yeah. Yeah, well, I would say a significant majority of people end up choosing the general power of appointment, saying, let my kids decide what they want to do. There's very many people who have very specific reasons not to give a general power to a child. And that's a very case-specific thing.
Right. The power of appointment is important when we are working with the clients to address certain kinds of tax concerns, specifically generation skipping transfer tax, which is really applicable in larger estates. So here we have those of $10 million of worth or greater. So I don't think we're getting into the weeds too much on GST tax here, but just so that you do understand, we may make a recommendation about using a power of appointment when we're doing this particular kind of planning, essentially.
Right, and so in very broad strokes, a generation skipping transfer tax planning requires us to create an exempt trust and a non-exempt trust. And the exempt trust that is used has a limited power, while the non-exempt trust must include a general power, so that we can include a portion of the assets in the next generation's taxable estate to avoid what can be a very onerous extra tax above and beyond the normal estate tax. So again, it really only applies an estate 10 million and up.
Another use that you'll see, another place you'll see the power of appointment is when a trust maker reserves for themselves a lifetime and testamentary power of appointment within Medicaid asset protection trust planning. So for those of you who do have a Medicaid asset protection trust, you would have reserved both a lifetime and a testamentary power of appointment. The lifetime power of appointment allows you to make adjustments to who your lifetime beneficiaries are of the trust. So you'll have your other lifetime beneficiaries who you can distribute principal out to. And by reserving this power of appointment, if you do happen to have an issue with one of those beneficiaries, or if we are counseling together that you collapse the trust and you need to, or amending the trust and you need to get your beneficiaries to sign off on it, you can really reduce the number of people who have to sign off, who are required to sign off on that amendment or that revocation. So that is a really important tool, gives you some flexibility in what's otherwise a sort of inflexible trust instrument. And then the testamentary power of appointment is where you reserve the ability to change who your after death beneficiaries are. So again, if you have a falling out or you want to incorporate some grandchildren that you didn't have when you first did the planning or something of that nature, then you can really change who your after death beneficiaries are. Oh, and that's explained here.
Yes, it is. So, but even in the many cases where the client never exercises their testamentary power of appointment in a Medicaid trust, it has another real important benefit, even if it's unexercised. Simply put, the mere existence of having the power, combined with the person's right to receive the trust income during their lifetime, causes the trust assets to be included in the trust maker's estate upon their death, even though those assets were fully protected from Medicaid beyond the 5-year look-back period. What the practical result of this is that the assets will receive that step up in cost basis to the date of death value. Because a lot of times we're funding assets in the trust, such as someone's primary residence that they bought in 1972 for $30,000, that today is worth $330,000. And they put in stocks that they acquired, even inherited, that have grown in value. We want that step up in basis because they're going to be under the 5.85 million limit. And we want all that growth to be wiped out when the assets pass to the kids and they end up selling the house or liquidating the stocks. So we have, I'm sorry, so for those who really like to know the tax code and their where these provisions come from, we have listed here the 2 code sections that really address how the provisions that have to be included in a Medicaid trust to ensure those assets are includable in the taxable estate.
So now we run through some ways that these different powers of appointment can be exercised. So with the testamentary power of appointment, typically the power holder is authorized to exercise that power in their own will or living trust. So they'll include a provision in one of their own estate planning documents that says that they've been given or they've retained a testamentary power and that they want to exercise it in the following fashion. And we'll go through some examples in a minute. The holder of a lifetime power of appointment is typically able to exercise that power in a living trust, but also any other notarized written instrument. And so for those of you who have exercised your lifetime power of appointment, many of you will have a separate notarized document that says that you have retained or been granted, really retained a lifetime power of appointment in your cases, and that you're exercising it as follows, and it will be spelled out for you. The method of exercising the power should be specified in the instrument granting the power. So it'll say right in the provision. So this is just an example of the standard exercise language, and it just says a testamentary power of appointment granted under this trust may be exercised by a will or living trust, specifically referring to the power of appointment. Goes on to say the holder of a testamentary power of appointment may exercise the power to appoint property among the permissible appointees in equal or unequal proportions, may designate the terms and conditions, whether outright or in trust. And the holder of a testamentary power of appointment may grant further powers of appointment to any person to whom principal may be appointed, including a presently exercisable limited or general power of appointment. So lots of language there, but you can see right from the start, it's very specific about how the testamentary power can be exercised in the will or living trust, and it has to specifically refer to being granted that power of appointment.
Yeah, and so you can give your child, for example, the power, a general power of appointment, exercised by the child's will, and that child can then say, I leave the remainder to my son, Aaron, in trust, and he has a further general power of appointment to appoint it to among his descendants or any other person he wishes. I mean, so it's a lot of flexibility, and you can really do some very creative multi-generational planning in this manner.
So we have a few more examples here. This one is of a limited power of appointment granted to a spouse. So here it says, my wife has the testamentary limited power to appoint all or any portion of the principal and undistributed income remaining in the marital trust among my descendants. So this is something we sort of alluded to earlier, is maybe in a marital trust we'll restrict it to descendants only. That way they can't appoint it outside the bloodline, but if they do have a falling out with a child or some other good reason to change the beneficiary, then they can do that. And here we know it's limited because it says it's a testamentary limited power of appointment, but the next paragraph says, my wife may not exercise this power to appoint trust property to herself, her estate, her creditors, or the creditors of her estate, which you probably recall a few slides ago was one of the factors of a limited power.
We then have an example of a general power of appointment, typically for a child. Peter Alonso has the unlimited testamentary, meaning exercisable through his will or trust, general power to appoint all or any portion of the principal and undistributed income remaining in his trust at his death among one or more persons, corporations, or entities, and Peter Alonso's estate's creditors. And Peter has the exclusive right to exercise this general power of appointment. So this will cause the assets passing in trust for Peter Alonso to be held in a trust. Upon his death, they will be includable in his estate, whether or not he exercises the power. Here's a retained testamentary power of appointment in a Medicaid trust. So this is the language which gives you the flexibility in your Medicaid trust to modify the dispositions. I have the limited testamentary power to appoint the remaining principal and income and the accrued or accumulated income of the trust to or for the person of any benefit, any person or entity subject to the limitations below. This is what we call a broad limited power. sounds oxymoronic, but that's what it is. Because the only people who it cannot be distributed to are yourself, your creditors, your estate, or the creditors of your estate. So you can leave it to anyone you want other than your creditors or your estate, which ensures the broadest flexibility. So if you've only left assets in your Medicaid trust to your children, and you have a falling out with all of them, for example, you can say, I'm going to leave it all to my nieces and nephews, or all to my favorite charities. So a limited power can be very broad with very little practical limitations. And Megan referred to this earlier, the lifetime power of appointment. This language, which I'm not going to read, will give you the flexibility to change your lifetime beneficiaries. And where this is especially important, because during your lifetime, and people want to have the ability to get back money that they put in the trust, and anyone who we've worked with on this, we've always had this conversation. What if I need the money? You know, I'm doing this to protect it for Medicaid, but what if something happens, I really need the money or just want it back? Because the trust, by its terms, restricts you from taking the principal back, if you recall that, for any of you who have done this before. So what we do, we say, okay, allow all your descendants or your children and spouses or whoever else is in your life, you can distribute to any one or more of that. Well, let's say 2 years into the 5-year look-back period, you have a massive stroke. And we have to undo the trust, which we can do, so that we can then revert to our typical crisis Medicaid planning strategy. Well, if you have 6 kids and 12 grandchildren, 6 of whom are minors, for your lifetime beneficiaries, there's no way we can terminate the trust because it requires the consent of all the beneficiaries. But by having this retained lifetime power of appointment, even if you are completely incompetent, because hand in hand with that, you will have the power of attorney that we've done with you that gives your agent the authority to exercise the power of appointment on your behalf and modify your trust, then the trust can be modified to get rid of all the other beneficiaries except for the one child who is most involved and can easily sign off on a revocation or modification of your trust. So having the lifetime power of appointment in a Medicaid trust is really a very essential planning tool. All right, come on, there we go. Oops, see, I went too fast.
So what we did, we just outlined for you guys in case you're at all curious and you want to look through your own documents. We've outlined where you can find some of these different powers of appointments. So if you have a Medicaid Asset Protection Trust, the lifetime powers would be found in Article 3. The testamentary powers would be found in your beneficiary subtrusts, which would be in Article 5. In the separate revocable trust for a married person, so you each have an individual revocable trust presumably here. The spousal powers of appointment are found in Articles 9 and 10, which would be like your marital and family trusts. And then the powers of appointment for children or other beneficiaries would be in Article 11. In a joint revocable trust for married couples, spousal powers are found in Articles 10 and 11. And powers of appointment for children or other beneficiaries are in Article 12. In a single person's revocable trust, the beneficiary's powers of appointment are in Article 8. So, take a look at your trusts if you're at all curious or you're just wondering what it was that we drafted with you. Because like Rich said, you probably don't recall the specifics of that conversation. The planning process really is a whirlwind. And so when you come in for your update meeting, we're happy to review that with you. And if you're looking through your documents and you're saying, what powers did I retain or grant, or why did I give this instead of that? And you want to make a modification, that's all part of the process. We'll have a conversation with you and we can certainly make changes to your documents as needed. So we're happy to have that conversation and make the adjustments.
And any questions you have before we sign off? Obviously, you can call us or send us an email, but if you have a final question, you can use the chat or Q&A. And if we don't see anything pop up in there in the next couple moments, we'll thank you for your participation. This year's program was, good, probably 25 minutes longer than most years, but there was a lot to cover. Next year we know there's already some important information we're going to share with you. And we'll also, have some changes that we're going to be incorporating. So by all means, keep up doing what you're doing, participate in these annual meetings. We will make a habit going forward of sending out e-blasts, because we only had like one sign up as of last Thursday, and then we ended up with 20 people. People forget that we're doing these. So we'll before each one, we'll send a reminder going forward all years. So thank you for your time today, and if we can be of service, of course, let us know. We're here to serve you and make your plan work the way it's supposed to. So we've enjoyed working with all of you, and we look forward to a healthy and productive rest of the 2020, and hopefully even a much better 2021 for all of us. So thank you very much, and have a good rest of your afternoon.